Good afternoon, and thanks for joining. Today is September 9th, and we are talking about permanent total disability in New Jersey. And as we begin this presentation today, thank you for joining us. Please remember, this is not legal advice as to any particular matter. This presentation is for instructional purposes only. It is also completely and totally live, so please ask your questions. I'm here to answer questions. It makes it so much more fun when I'm answering questions as we do. Type your questions in as we go, and when we get to the end of the presentation, I will answer your questions in the order in which they are received. I will say your first name, so you know that I'm answering your question. I will then read your question for the whole group. Of course, I will strip out any identifying information and then do my best to answer your question today. We're going to talk about a really interesting topic, which is permanent total disability in New Jersey workers' compensation cases. When you say to me, Greg, is that really an interesting topic? Yeah, I think it's really interesting. So I'm going to talk about what are the basics of permanent total disability, how is it found, what is counsel going to do for you, how are we going to talk about these cases. We'll talk about how we're going to determine exposures and those types of things. And then we're going to talk about the edge cases. So often in a permanent total case, there are pre-existing disabilities which are complicating the finding of total disability. And so I'm going to talk about New Jersey's Second Injury Fund, and I'm going to talk about odd lot claims. So that's what's on the agenda for this morning, or this afternoon, excuse me. Also, if you're new to this webinar, please also note that these are all recorded. And so if you want to play them back, you can go to our firm website and you can play them back. We also release them as an audio-only podcast, so it's another great way to sort of catch up with what we're doing. All right, let's get back into it. What is permanent total disability? And there are some definitions from the statute, and there are 4 distinct permanent total disability theories that can be pursued by the injured worker, and we're going to talk about each of them today. So the first thing I'm going to do is I'm going to walk through the statutory definition of something we'll call statutory permanent total disability. Okay, so statutory total. And you'll sometimes hear counsel say this person is statutorily totally disabled. And here we have an image of our poor worker who lost both legs in an accident. Well, that person is totally and permanently disabled according to the statute, because the statute says in section C, subsection 20, quote, the loss of both hands, both arms, both feet, both legs, both eyes, or any 2 of those as a result of any one accident shall constitute total and permanent disability. So in this picture you see here is a worker who lost both legs, but if they lost one leg and one arm, or one eye and one leg, that would all count as that statutory total disability. And that's the term of art that you're going to hear us talk about as practitioners. We're going to say this person is statutorily total or statutory total. Now, again, we're looking at any one accident that meets the criteria for total disability under the New Jersey statute. The claimant or the petitioner would be entitled to 450 weeks of permanent total disability benefits. After that, they're entitled to ongoing benefits, but interestingly, they might not be in the permanent total case. Now, the way the benefit is calculated is to take 70% of their pre-injury average weekly wage and pay it going forward for that first 450-week period. This year, 2024, the maximum rate is $1,131. So your maximum exposure for a permanent total disability this year for someone who met the definition of statutorily totally disabled would be for 450 weeks, payable at $1,131 a week. Now, what happens if they return to work during that 450-week period? All right, maybe they don't work for us. Maybe they've gone to some new employment or opened their own business. Well, they're still entitled to that 450 week of benefit, but maybe after that 450 week period, they are not. For the worker who does not return to work, yes, they would then be returned, would still be entitled to ongoing benefits, again, calculated at 70% of average weekly wage and subject to the maximums and minimums in effect for the year of the loss. But you should note that we should be thoughtful about that. 450 weeks is roughly 8.5 years. So what happens at the end of that 8.5-year period? Well, then their benefits would continue under Section 12B of the statute, but maybe they don't. And maybe you would reduce the award because they've returned to work or they're pursuing significant volunteer activity, right? So that's possible. So that's statutorily totally disabled. And that's really the first and simplest form of permanent total disability in this jurisdiction. Again, they meet the minimum requirement or the requirement in the statute to be found statutorily totally disabled, and they'd be entitled to that 450-week period and then ongoing benefits if they remain totally disabled after that period of time. Now let's look at the second legal theory, which would be something sometimes called by attorneys legal permanently total disabled or straight permanent total disability. Now this is a claimant who has no workability, and I'm going to talk about what that means. But they don't meet the statutory definition. In other words, they didn't have amputations of one or more limb. They didn't lose an eye or a hearing in association with the loss of one or more limb. So this is the worker, and if you want to imagine your claimant who says, I got a really bad back injury and it progressed over time and now it's so disabling I can't work. Okay, that is someone who's claiming what we'd call straight permanent total disability or legal permanent total disability. In other words, I don't meet the statutory definition, but I meet the legal definition for permanently and totally disabled. And again, this is much, much, much more common. So what does that mean? Well, the legal standard is disability that is permanent in quality, meaning it's not expected to improve, and total in character. And it could be from physical or neurological or psychiatric injuries, or the combination that leads them to in such a circumstance that they're not going to improve and they have no working ability. That's what is statutorily defined. How do they show this? Well, first, they're going to have to demonstrate by at least one medical report or medical expert report that their medical expert thinks that they have a permanent and total disability. Now, many times you'll see cases that settle for far less than total disability where their doctor says they have a total disability. Okay, so just because their doctor says it doesn't mean that's a finding of total disability, right? We can still challenge this. But the case law has explored exactly what this means, and there's a lot of case law discussing what is and what is not permanent total. Now, in my mind, to be permanently and totally disabled, there has to be very significant injuries and a very significant impact on the petitioner's ability to work in a stable job market. That's literally from case law. But there's also case law that kind of opens it up. And some case law says things like, quote, a workman, and again, this decision is coming from the 50s, so that's why it is not saying a worker, but a workman need not be bedridden, paralyzed, or unable to get about, nor is his ability for light or intermittent or sedentary work inconsistent with being totally disabled. Okay, that means, you could look at this person and say, well, they're not completely unable to do anything. They can certainly carry on their activities of daily living. We're really talking about this in a working context. Carlson case says, quote, we think it's clear that the petitioner who cannot compete in the labor market, pass a pre-employment physical, or otherwise appear as one whom an employer would be interested in hiring, other than as an act of charity, close quote, could be permanently and totally disabled. And then the Barbarato case says, the inability to find work traceable or attributable to the employee's compensable injury is tantamount to the inability to perform work, okay? So really what we're asking, the question really becomes, does the person's inability to work currently, is it completely related to the accident, okay? Now, in regard to employability, it's not same occupation. So if the person was a mason, they cannot prevail by saying, well, I have this injury, it's, I can still carry about my activities of daily living, but I can't work as a mason anymore. And for that reason, I'm permanently and totally disabled. It is any work in any stable job market. And by the way, that word that I keep saying, stable job market, is important too. When there is a really bad market, maybe for construction employees, and they can't find a job doing construction work because maybe construction work has slowed down, that doesn't mean they're permanently totally disabled. They could go look for work in another industry. Any stable job market, any other industry is acceptable. So really, when you boil this down to show that they are legally totally disabled, again, they don't meet the statutory definition, they have to show that they are not capable of doing any job. And if the only job they can do or is something they're not qualified for, that's their argument for why I am permanently and totally disabled. Now, New Jersey also allows a third definition of permanent total disability, which we're going to explore a little bit more later in this presentation, but I want to touch on it here. And they have a theory called odd lot total disability, which comes from case law. And it says where they have a severe injury and a pre-existing non-medical condition that prevents them from finding work. Well, what does that mean? A severe injury, so that's our workplace accident, plus pre-existing non-medical conditions. So we're looking specifically at non-physical injuries, non-psychiatric or neurological conditions. And the case law says that this can apply where their physical injury, the injury attributable to the workplace, is at least 75% or higher of partial total disability. We're going to explore this a little more further in the presentation because this is where it gets really interesting. And the fourth opportunity for total permanent disability in New Jersey is second injury fund total disability. And this is where the person has a compensable accident or occupational injury, but when it combines with all of their pre-existing medical conditions, they are now completely unemployable. And again, we're focusing on medical conditions, which would include neuropsychiatric conditions. A lot more to talk about on that to come. So the four legal theories that the petitioner can rely on to establish their entitlement to permanent and total disability. The first one is statutory total disability. Again, loss of two limbs, loss of body parts. They meet the requirement whereas laid out in the statute. That is statutory total disability. Those cases are pretty rare. I would say of all the permanent total cases that we defend, it's probably 10 or 15% of them. I'll also suggest to you that knowing the definition of statutory permanent disability, which is the loss of any two limbs or eye and ear in combination with the loss of a limb, would lead to a permanent total disability, should inform you as an employer or workers' compensation carrier about what to do in those cases. My advice would be, hey, you know it's going to be permanent and total disability. You might want to consider stipulating to it early so you don't pay temporary disability because you know they're going to be permanently and totally disabled forever. And so there really is no value. The rate that you're going to pay the rate that you're going to pay temporary total disability is going to be the same rate that you would be exposed for permanent total disability. You might as well start getting those 450 weeks running. Okay, so that's a little bit of a practitioner tip. The second type of permanent total disability is that is found through legal proofs, essentially arguing that their medical condition leaves them unable to find work in a stable job market. And then there's two additional potential total disability situations that I'm going to talk about next because they're very interesting and they happen with some frequency. First is an odd lot permanent total disability, and the second is second injury fund cases. So let's dive into those cases where we're going to be looking to either pre-existing or non-work related situations or conditions that render a permanent total disability. And let's talk about odd lot first. This happens when there is a severe injury at work, very significant injury, and that injury has to account for at least 75% of the permanent partial disability. So again, we're going to say as a floor, their permanent partial disability related to their workplace accident is at least 75%. When that happens, when you reach that floor, you should be thinking, oh, wait a second, is this a case where the petitioner is going to be able to argue that they are actually permanently and totally disabled because they can point to these odd lot factors? So let's dive into what those factors could be. Well, these are non-medical factors. And courts have said that these factors include things like no English language skills, being illiterate, being enumerate, having a lack of generally transferable skills, or having a learning disability or intelligence impairment, which would prevent you from finding work, again, in that stable job market. And I want to bring some case law forward into this to give you an example of what it looks like when the trial court says that someone has a odd lot permanent total disability. The first case I'm going to look at, or I'm going to quote for you, is Padilla. And this is pretty much the seminal case on odd lot. The petitioner, and I just dragged this right out of the case law finding. Petitioner is age 57, married, father of 3 children. He's born in Puerto Rico. He attended school there through the 2nd grade until he was orphaned, and his formal education ceased. So the first thing we're saying here is he's 57 years old, he's got dependents, and he has no formal education after 2nd grade in a different country. In 1959 or 1960, the record's unclear, he moved to Perth Amboy, New Jersey, and has resided there ever since, except for a brief return to his homeland. Living and working in an almost exclusively Hispanic environment, remember this case law was decided in the 1950s, petitioner has had little exposure to the English language. Although petitioner comprehends and can converse in English to a very limited extent, he can read and write only in Spanish. Because of his limited education, his arithmetic skills encompass only extremely simple problems. While the petitioner has an extensive employment history, his work skills, even before the 1983 accident, were very limited. While residing in Puerto Rico, the petitioner was employed as a laborer cleaning coffee beans. In the United States, he worked at varying times as a dishwasher, material handler, welder, punch press machine operator, and working foreman. It was as working foreman that the petitioner operated the plastic molding machinery which caused the accident and amputation of his hand and wrist. In this case, the appellate division found that when you take his medical factors, which was the amputation of his hand and his wrist, which led to a 75% permanent partial disability, but then you add in the other factors, lack of formal education, not being able to read and write in English, poor arithmetic skills, they said ultimately he has a permanent and total disability because of all those non-medical factors. All right, now I wanted to bring that case law forward and read it for you because doesn't that sound like so many claimants that we see oftentimes with a lack of transferable skills and maybe not proficiency with the English language? So really, when you're looking at these odd lot cases, you're going outside of medical factors, and we've got to start taking into consideration the social circumstances of the individual petitioner, which is very difficult and not a place we want to be in. How do you defend these cases? Well, oftentimes you're going to have to bring in an employability expert. You're going to have to bring in a vocational expert. And I would tell you it's table stakes that you should get their application for the job that they applied for and that they were working at, as well as the job description, so you can determine exactly what their skills were that they presented to the employer as they took that job, which unfortunately led to their final injury, which now forms the basis for their odd lot claim. These cases should be vigorously defended. And again, that odd lot determination of permanent total disability should only apply to very significant injuries where the permanent partial disability is 75% or more. All right, let's talk about the last opportunity for permanent total disability, and that's where the second injury fund is coming into the case and is going to be contributing towards our case, towards the claimant to be found permanently totally disabled, and actually contributing to reducing our exposure. So New Jersey still has a second injury fund. It was created to encourage employers to hire employees with pre-existing disabilities, primarily war veterans. New Jersey's second injury fund was created in 1923. And if you think about what was going on in 1923, it was a lot of veterans returning from World War I with amputations and injuries and significant harms that they experienced in the war. And nobody wanted to hire these employees, someone who comes back from the war with an amputation or a limb or a significant injury, because they knew, well, the statutory definition of total disability is if anything else happens to this person, I could be responsible and liable for their permanent total disability for the rest of their life. And so the second injury fund was created as a response to that. And the idea here is that the second injury fund would take responsibility for the pre-existing disability and offset our exposure for pre-existing disability. And our second injury fund would come forward, and after the 450-week period, would then pay all of the 12B weeks, which are the ongoing weeks of benefits to the petitioner until they die. So this could result in a very significant reduction in our exposure. And again, it was intended and created to try to encourage employers to hire those people who already had pre-existing disabilities. So it had a very noble purpose. Now, The second injury fund only pays where the petitioner is now currently totally disabled, and they don't care whether it's statutorily disabled or simply legally disabled, and the petitioner had some measurable disability before the employment accident, and the combination of that prior disability plus the employment accident now renders them totally disabled. In order for the second injury fund to contribute and offset our exposure, the petitioner or the respondent must claim or concede total disability. Because remember, we can simply concede total disability and then go and seek reimbursement from the second injury fund. It is our burden, and it would be the burden of the petitioner, to show the disability occurred before the last employment accident. And there has to be a stipulation or finding that the petitioner is now totally disabled. It's simply not enough to say they're not working because they retired. They actually has to, would have been working but for the injury. Now, the mechanics of paying this is pretty amazing. We're still going to pay for the new disability up to and the maximum of 450 weeks, but the fund is going to pay for the remainder of the total disability period under Section 12B, which could be for the petitioner's life. So let's do a very specific example of this, and I want to show you how significantly this could possibly impact your exposure, and why when you have a permanent total disability case, you should always be thinking, wait a second, maybe this person is permanently and totally disabled, but is there any opportunity here for me to gain contribution and essentially exposure reduction by involving the second injury fund? So let's take a look at our happy employee, comes to work, doing a great job. But before they worked for us, they had already lost their right foot in an unrelated non-workplace loss. Does it have to be in a war? No. Could it be they were snowboarding or something and they injured? Yes. So it doesn't matter what the pre-existing injury is. They could have even been born with it. It could be congenital. It could be a high school injury. It does not matter that they have a pre-existing condition that impairs their physical ability to work or mental ability to work. So to make this simple in our example, we're going to pretend they previously lost a foot in an unrelated non-workplace accident. Now they're working for us and they have a new accident. And at that accident, they unfortunately lose the other leg or the other foot. They now meet that definition of statutorily totally disabled, right? Because they've now lost in the second accident, the one with us, they've lost the other foot. That could open us up to tremendous exposure for permanent and total disability. So let me show you the math as to what our exposure would be if there was no second injury fund involvement. If we simply had an employee who lost both legs, or let's imagine that New Jersey didn't even have a second injury fund. What would our exposure be? Well, the exposure is going to be calculated as the initial period of disability, and that could be up to a maximum of 450 weeks, plus the number of weeks in that employee's life expectancy, plus whatever medical costs for life are. That's how we're going to calculate up our total exposure. And again, that would be how we'd calculate total exposure in any permanent total disability case, whether that's statutorily totally disabled or legally disabled. So the initial period always has a maximum of 450 weeks. The number of weeks in life expectancy is going to come from a life table. We'll use a rated age chart. Here we use the Social Security decennial life tables to calculate that. What are the medical costs for life going to be? Well, those could be projected. A simple way of doing that would be perhaps to get a Medicare secondary payer allocation done so that you could determine what is their future medical going to look at, and there's your total exposure. So to make this simple, let's imagine that this person had an average weekly wage of $600 a week, and they are 61 years old. So if they lost both of their legs while working for us, or they lost one leg and had previously had the loss of a prior leg from an unrelated accident, and again, we're pretending there is no second injury fund, we would be exposed for 450 weeks of compensation. That would be the initial period. And then we'd be exposed for the number of weeks in their life expectancy. And because this petitioner is 61 years old, they have a 17.3-year life expectancy, which means 449.6 weeks, plus whatever the medical cost projection is. And so I can tell you just by using back of the envelope math that our exposure is more than $500,000. It's $539,400 plus the cost of future medical. So that's a great example, kind of walking you through how you would do the exposure analysis and then exactly what it would be for someone who is statutorily permanently and totally disabled and there was no pre-existing injury or there was no such thing as the second injury fund. But now let's pretend there is a second injury fund. And let's pretend that the second injury fund says that the petitioner's prior disability, the prior loss of the other foot, only contributed 1% of disability to their overall award or overall finding of disability. Okay. Now remember, when does the second injury fund contribute? Well, first there has to be a concession of total disability or legal finding of total disability. Next, the petitioner had to have some measurable disability before the employment. And the combination of both of these things together now rendered them totally disabled. Well, I think we've met all of those requirements in this circumstance. So we know what the prior loss of a foot is, and we can pull it right from the statutory chart of disabilities, how many weeks of compensation that should be reduced. But we're going to pretend that we only get a 1% contribution from the second injury fund. So on the left-hand side, you can say, look, with no fund contribution, we would pay 450 weeks, then another 449.6 weeks plus all the medicals, and it would be a minimum of exposure of at least $539,400. On the second chart, what if the second injury fund only contributes 1% of disability? So Greg, we think that prior injury was not disabling. We're only going to give you a contribution for 1%. That's 4.5 weeks. Well, we would then pay the remainder, 446 weeks, 0.5 weeks. We would then never pay anything under 12B, so going forward after the initial 450-week period expires, and our total exposure drops to $267,600. So in this extreme example where the fund is contributing barely anything, we have just reduced our exposure by roughly a half by seeking contribution from the second injury fund. So as you can see, this is a tremendous opportunity for us to reduce our exposure in permanent and total disability cases. And obviously, I played with this. I did this purposely. I said, the fund's only going to contribute 1% for a loss of the foot. No, they should. They should contribute something like 200 weeks, 250 weeks for the loss of a foot, which would significantly reduce that exposure much more, okay, to perhaps half of what that $267,000 is. So this has a tremendous impact, and it's something that should be taken into consideration every time you have a permanent total disability case. How do we get contribution from the second injury fund? Well, there are a few legal steps that need to be taken care of. The first and most important one is someone needs to file a verified petition, that's the term of art, seeking to join the second injury fund into the case and gain contribution from the fund. It does not matter who files the verified petition, but in general, we want petitioner's counsel to file the verified petition. If we do not have them file it, we can file it ourselves, but just be careful because now you may be conceding total disability. Supporting that application is going to be documentation and specifically medical reports finding total disability, and then any other information that's going to be necessary for us to calculate the total potential award and what the fund is going to contribute. So this is a real matter of doing some good bookkeeping and making sure that we produce enough documentation so the second injury fund will contribute. Now, who represents the second injury fund in these cases? Deputy Attorney General's office represents the second injury fund. Who pays into the second injury fund in New Jersey? It is in general insurance carriers and self-insured employers who contribute to the second injury fund. And by the way, it used to be called the 2% fund because it was 2% of premiums were paid to fund it. I think it's now between 7 and 9% of premiums are going into fund the second injury fund. So truly, this is funded by you, and you should be arguing strenuously for contribution because it's money that you paid, it's coverage that you are securing. Now, there are some circumstances and some things that the fund will never pay. So they never pay for the cost of medical treatment. That is always going to be our responsibility. They never pay for cost of suit or any attorney's fees. That is all borne by the petitioner and the respondent. The second injury fund can never contribute towards a Section 20. What's a Section 20? It's a lump sum dismissal of all claims. They are not allowed to contribute to a Section 20. The second injury fund never pays dependency benefits in a death case. They will never contribute in a partial disability case. Remember, it only applies in total disability cases. The second injury fund has a legal defense and does not have to pay when the last accident by itself is totally disabling. And the second injury fund also has a legal defense and does not have to pay when the injury itself progresses into total by itself. So those are circumstances where the condition worsens over time. You'll hear some common objections from the second injury fund, and I've been at this for more than 2 decades. I've defended and brought forward many claims against the second injury fund, and there are some common defenses that they will bring, that they are very well trained to bring in our workers' compensation context. The first one is that the last accident by itself was totally disabling. Okay, now this is relatively easy to overcome, this defense, by simply pointing out the severity and the nature of the pre-existing condition and why it should be considered for contribution. The second thing the second injury fund will object, and again, you'll have a deputy attorney general who does nothing but these cases all the time, is that the person is not totally disabled from their last accident. And that's really hard for them to do in a case of statutory permanent total, but where the argument is for straight permanent total or legal permanent total, where essentially there's a number of little conditions or injuries that arise and they're claiming that the person is now totally disabled, they will make that argument. And the last objection they'll make is, hey, Greg, this person's not totally disabled because they could have a job. I mean, they could be a Walmart greeter. And so we have to be prepared to answer that as well. So moving forward, let's give you some takeaways, some things you can act on and use going forward. When you hear us talk about statutory total or legal total, now you know what those terms mean. You also know why pre-existing disabilities, and particularly non-work-related conditions, things like illiteracy, social standing, lack of transferable skills, lack of vocational ability, lack of a work history, can be utilized by the petitioner to argue that they are now totally disabled under the odd lot doctrine. And finally, I hope you saw from our illustration how contribution by the second injury fund, even if for just a small amount of money, may significantly decrease our exposure. So let me dive over here. I did see at least one question popping up while I was talking. So let me open up my question panel here and see what we got. Okay. So I have someone saying, I'm having difficulty hearing you. Sorry about that, Margie. Came back in, looks like she's still not hearing anything. All right, so can't answer that, Margie. It does sound to me like we had audio during the presentation. Yep, it's coming through the headphones, so I can't answer that. It might be on your end rather than ours, and I didn't see any other questions about that. All right, I'm hoping there's more questions than this. These are just comments about what's going on in the presentation, but doesn't look like it. Okay. Thanks for joining me. If you do have any questions and you just didn't type them in yet, always feel free to email me or call me with any of your questions. I'm always happy to answer them and talk about any topic in New Jersey workers' compensation law. So I hope this was useful for you, and I hope you have a great rest of your week. Thank you for joining us, and next month we'll be talking about a new topic in New Jersey workers' compensation. Have a great day, everybody.